The beginning of Article 1 says all legislative powers herein granted are vested in Congress. And the basic point of that introductory phrase is to make it clear that Congress has the following legislative powers, no more and no less. That there's not some general grant of legislative power. What's different about the federal constitution as opposed to state constitutions is the grant of legislative power is limited to the grants in Article 1, Section 8. And so Article 1, Section 8 is not merely illustrative of what Congress can do. It's meant to be the complete list of legislative powers. There are 18 grants listed. They list those grants in part because they want to make it clear that other things not listed aren't being granted to Congress. Under our federal constitution, the idea and the hope was that although we're granting Congress a new host of legislative powers, we're not granting them authority over family law across the nation. We're not granting them authority over criminal law across the nation. We're granting them a series of specialized authorities: commerce, patents, bankruptcy, naturalization, power to raise armies, the power to declare war, etc. So if you look at some of the state constitutions, they actually just said the legislative power shall be vested in an assembly and a senate. And in those systems, there was no limitation, no subject matter limitation to what those legislatures could enact. So while the Maryland legislature has general legislative power and can pass pretty much any law it wants to, consistent with its Bill of Rights, the U.S. Constitution has a double layer system of limitations, right? The first layer of limitations is, does Congress have subject matter authority over the matter in question? Right? Can Congress pass a nationwide murder statute, for instance? The second layer of protection is it consistent with the Bill of Rights and other implied limitations on the power of government